Thank you. And then on Miss Jallow, Your Honor, this has gotten quite complicated because I did go over the guilty plea form with Miss Jallow back in September. She's here for sentencing. I maintain that I very clearly explained what the agreed recommendation would be, but Miss Jallow is saying she didn't fully understand that she would have to follow through with recommended treatment and has a lot of reservations about that. And I think she has expressed that she would like to just address the court herself and express her wishes regarding sentencing. And that was sort of where the conversation was left off.
This is where the whole situation starts getting messy. Even the attorney admits the client didn't understand the plea deal. In court, confusion like this immediately raises red flags to judge, and we can already feel the tension building.
58923. You entered a guilty plea on
September 20th, Your Honor.
yes, September 20th, 2023. It looks like I went over that with you, and then we set sentencing over. Okay, I'm looking at the plea form right now, and it says no criminal law violations. This is the recommendation of the parties. No criminal law violations. Alcohol and drug evaluation. Don't go back to South Center Mall. Obtain a chemical dependency evaluation and complete whatever treatment is recommended. That was entered, and I accepted that guilty plea. So we're on for sentencing, and presumably you've had that substance abuse evaluation. I'm hearing that you have not done that.
When the judge reads a plea form out loud, everything becomes clear. Nothing was hidden. Treatment, evaluation, restrictions, it was all there. No wonder the judge's tone starts turning firm. She expects responsibility, not excuses.
Sorry, Your Honor, I didn't mean to cut it. We've continued this set over sentencing a few times for Miss Jallow to get the evaluation. And she has expressed to me that it's just at this point something she is apparently unwilling to do. And so I'm a little bit, yes, I'm not sure how to proceed.
The moment the attorney says she is unwilling to do it, the energy changes. Judges get frustrated fast when defendants refuse basic court orders. And you can literally see the judge shift into control mode.
Come on camera, I can't see you.
Yeah.
Miss Jallow, are you telling me that you're just you're gonna disregard the court's order?
Well, I don't want to do it. I thought my thought on the deferred sentence is that if I didn't do it, I just didn't do it. And it stayed on my record.
This was intense. The judge asked directly, "Are you going to disregard the court's order?" And the defendant's response feels careless. At this point, the judge realizes she's dealing with someone who still doesn't grasp how serious this is.
Now, Miss Jallow, I went over the plea form with you. I know I am thorough in going over the plea form. So I'm certain I don't even need to listen to the audio because it was me who went through the plea form with you, not a pro tem. I'm looking at.
Here we see the real problem. The defendant genuinely thinks that not doing treatment just means the case stays on her record. Court doesn't work like that. The judge isn't being harsh. She's trying to make her understand the consequences.
Now have, sorry, the system is moving a little slowly.
Just for some background, Your Honor, we were initially trying to negotiate with the Burien matter, and we were going to dismiss one of the two cases if she got into drug treatment in another one. So I'm pretty sure she was aware that that was on the table.
And you also now have a pending assault in the fourth degree domestic violence, assault in the fourth degree charge where it looks like there's some kind of ordered effect out of Kent. And the Kent, am I reading that correctly?
When the judge starts listing her other cases, the entire tone shifts. This isn't just one slip-up. There are multiple pending charges and violations. You can almost see the judge thinking, there's a pattern here.
Get up to 364 days in jail for this. This is a criminal offense, and the parties asked to send sentencing over so that the court can get a copy of a substance abuse evaluation so the court can determine what the appropriate sentence is. The court's not bound by any recommendations that the parties are making. The court doesn't have to follow through with any recommendations. And I thought it was perfectly reasonable, all things considered, for you to go get a substance abuse evaluation as the parties had recommended. So if the city is recommending a 24-month deferred sentence, that doesn't mean I have to follow that. In fact, you failed to appear in this case. You have bail posted. You're now telling me that you don't want to go get an evaluation.
This line says everything. You can get up to 364 days in jail. Judges don't say that casually. It's a wake-up call. And even after hearing that, the defendant still seems confused about how serious this is becoming.
Forgot court. As soon as I found out that I missed court, I went down there and I paid for the bail. If I would have known I had court, I just, I have other things going on in my life, So, I mean, it wasn't like I ran, I didn't want to go to court. Do you think I wanted to go pay $500 to get bailed out on this charge? I accidentally forgot about court. People make mistakes in life. Sorry.
Here the defendant becomes emotional, explaining she accidentally missed court. And sure, mistakes happen, but the judge clearly doesn't trust her judgment anymore. Sympathy only goes so far when you have repeated issues.
You're trying to think that you know how I should be doing my job, but that's not how it works. The bottom line is, and if you're going to go off camera, you have to come on camera. Otherwise, I'm not going to allow you to.
Okay, what do you want me to do? Okay, I'll go get the drug and alcohol evaluation. I'm done with this. I'm done.
From now on, and I'm setting sentencing over, and you have to get a substance abuse evaluation between now and that sentencing hearing where you have to appear in person. Okay? I'm not going to allow you to be able to control your court hearing by just removing yourself from the screen or interrupting me. You must appear in court in.
Honestly, the judge is being patient here. She gives one final chance. Get the evaluation, bring documents, and appear in person. Judges don't always walk a defendant step by step like this. It means she still wants to leave the door open for dismissal.
Your next court
done
date.
yet? Are we done?
We're not done. We're not done. Hello. Your next court date is March 13th at 10:30. Is that a Wednesday, Nessa?
What did you set up?
This is exactly why you are not going to appear in Zoom again, Ms. Jallo. You are going to be here. Is that a Wednesday, Nessa?
Yes, Your Honor, that's a Wednesday.
Okay. March 13th at 10:30, you will appear in person at the Tacoma Justice Center for
Okay, I'll see
sentencing
you then.
with your substance abuse. Don't you dare hang up, Ms. Jallo, or I will order a warrant for your arrest.
Well, I mean, what do you want me to do? You told me my next court date's March 13th.
What
I'll
I'd like
be
you to
there.
do, what I'd like you to do is act like you're actually in court. This is the reason why you're not allowed to appear remotely anymore. We're going to email you notice of your next court date. If you do not get an email from us by Tuesday, call the court so that we can follow through to make sure that you receive this document. Do you want to speak to your attorneys before you hang up?
No.
Okay, come back March 13th here at 10:30 with the results of your evaluation so we can go forward with sentencing. You now are free to leave. Thank you.
And then the viral moment. Don't you dare hang up. That's when the judge's patience officially runs out. Zoom court isn't a place to argue or click away. And this was her final warning. Either follow the rules or face serious consequences.